Yes. Sir, presentation is it visible now?
Yes, yes, it is.
Yeah. So, very good evening, all. Hope I am audible and visible, and my presentation too.
Yes, Madhu.
Yes. Yes. So, in this session, we will be looking into the Arbitration Act 1996 of UK. Before starting the session, let me explain why we have chosen this Arbitration Act for this session. Since the participants here are going to attend the MCRB assessment, which is by CRB based in UK, of course, you will be having some questions from the Arbitration Act of UK. So, as per our discussion in the previous session, the ancestral model law, it is the parent of every arbitration act in the, I mean, in worldwide. So internationally, ancestral law is the template which is being used as template, and the countries they do follow, they do adopt the provisions of this ancestral model law, and some countries they do customize based on their requirements. For example, ancestral model law does not speak about the timeline for completion of the proceedings, whereas in India, that is Arbitration Conciliation Act of 1996 in India, the Arbitration Act speaks on the timeline for completion of the proceeding, which is 12 plus 8 months. So this some provisions varies from country to country. So in UK, as I said, it is Arbitration Act 1996. In UAE, it is Federal Arbitration Law and Abu Dhabi Arbitration Center and Dubai International International Center, etc. So these are the laws. I mean, these are some of the laws which are being followed in different countries. So this Arbitration Act 1996 of UK, it has been applied in the jurisdiction of England, Wales, and Northern Ireland. And this Arbitration Act of 1996 has 110 provisions which regulates the stages of arbitration process since the beginning. That is the invocation, the commencement of arbitration proceeding, and various other stages like witness examination, the document submission, and of course the challenge procedures and the enforcement. So it covers all the stages of the Arbitration Act. Founding principles of this Arbitration Act, you know, the major essential of Arbitration Act of every nation is to limit the court intervention, of course, and to not delay the dispute resolution proceedings. So that is the major motto for to adopt the Arbitration Act specifically in every nation, and to the impartiality of the tribunal and not to delay any dispute resolution process. And we have been telling this time and again, the arbitration agreement, it has to be in writing. So it has to be in text format and it should be signed by the parties. So only then it is enforceable. Of course, this the universal rule of the arbitration agreement. And the arbitration agreement, to resolve your disputes through arbitration, it is not compulsory that the arbitration has to be in your dispute resolution clause of the contract. It can be either as a separate dispute resolution process in the contract, or it can be a standalone agreement. So based on the parties consent, this can be decided. And next is general duty of the tribunal. The Arbitration Act of UK defines this. The tribunal has to be fair and impartial. It should not favor one party and should not be biased to another party. And he should give equal and reasonable opportunities to both the parties. So he has to make sure, because if this is not being followed, then the party who is suffering, they could challenge the arbitration award by the arbitrator. And he should not unnecessarily delay the process and the expenses. He should not increase the expenses. And he should decide on the matters of evidence, and he can decide on the matters of the evidence and other procedural things if the parties are not mutually agreeing on those matters. Next is IBA guidelines on conflict of interest in international arbitration. Let me give you a short illustration so that you can understand very much. Consider that you're being appointed as an arbitrator, or you have some sort of dispute in your company, and you want to invoke arbitration and resolve that process through this arbitration proceedings. So first, you're approaching some person. uh, to become an arbitrator, there is no specific requirement. It depends on the parties' need to resolve the dispute. For example, if the parties wish to resolve some technical sort of issues, in that case, obviously the parties will choose the technical arbitrator, and it differs from case to case. But none of the arbitration laws mandates on the qualifications of the arbitrator. This is on the other side. The arbitrator, he should mandately should not have any past relationship with either of the party. So for that, the parties will check on the conflict of interest before appointing him. So the IBA guidelines has formulated some rules on this. This is not some mandatory rules which has been adopted in all the arbitration acts of the country, but they mandatorily follow this. So they have four category of arbitrators. I mean, they have categorized the arbitrators on the four list. That is non-waiver red list. The arbitrator who's the director of the company, or directly associated with the dispute in hand, or directly who the party themselves. They will come under this non-waiver red list. So this kind of people cannot be appointed as an arbitrator for that dispute. And next is weighable red list. So the employees, maybe he may not be the part of the dispute, or may not be directly associated with the parties, but he is somewhat, uh, employee of the company, or he might have given some advice to the specific dispute. So that category of people will come under this weighable red list. So after disclosing the relationship, the past relationship of the arbitrator with the parties, the arbitrator will
Okay, I think
of
some
the
tech,
dispute in hand. People,
sorry,
yes,
Madhu, there was some interruption for a few minutes. You may run from the previous slide.
yes, sir, sorry, sir,
Yes, please.
sir,
Yeah.
is it okay now? Yeah. So, general duty of the arbitral tribunal. The Arbitration Act of 1996 speaks on the duty of the arbitral tribunal. Of course, is the common thing which has been followed in all the arbitration proceedings. The tribunal, he has to be fair and impartial. He should not bias any of the parties, and he should give equal and reasonable opportunities to the parties. If one of the party is not being given a proper opportunity to represent his case, so the suffering party, he could definitely challenge the tribunal appointment before the court. And next, he should adopt the procedures that does not unnecessarily delay the procedures and the expenses. As you all know, the arbitration proceeding, though it is timely, very much critical, it is very much expensive compared to the court proceedings. So the arbitral tribunal should make necessary steps to avoid those expenses and delaying it. And if the parties are not coming forward to discuss and decide on the evidence and other procedural laws, in that case, the tribunal, he will decide and proceed the matter. Next is IBA guidelines on conflict of interest in international arbitration. This IBA guideline, it is not been incorporated in all the arbitration laws, but it is mandatorily followed in the appointment of arbitrator, because as you all know, the qualification of arbitrator during his appointment does not matter, because none of the arbitration act does not specify regarding the qualification requirements. Although the conflict of interest, the relationship of the arbitrator, with reference to the parties, that is both the parties, and with a reference to the dispute in a hand, and with reference to the counsels, that is the advocates and lawyers representing the parties. Of course, the outcome of the disputes. We should not have relationship with any of these four categories. So if he falls under this category, then the parties, they have to mutually agree for the appointment of the arbitrator. If not, if the arbitrator has some conflict with all these disputes, parties, and counsel, and the outcome of the dispute, then such kind of appointment and the arbitral award could be challenged before the court. So the IBA has categorized the arbitrator based on the four list. That is, first one is non-weighable red list. The parties themselves or the managing director of the company. So those people will be categorized as non-weighable red list. So as you know, the director or parties themselves, they cannot adjudicate, they could not decide the matter in dispute. So that category of arbitrator could never be appointed for that dispute in hand. And next is weighable red list. The employee of the party's company, or any of the relatives of the arbitrator. So that kind of category will come under weighable red list. So if the parties are mutually agreeing on the appointment of such kind of arbitrator, then it is not a problem. So this is weighable red list. Next is orange list. Consider that I have given some legal advice for the parties for some other matter, maybe 3 years before, and I have represented the parties, that is all 3 years before, but now I have been called for appointment to adjudicate some other matter. So that kind of, people will come under this orange list, and you know, this orange list is not restricted for appointment. So it is kind of green flag for the appointment. And next is green list. Green list is like the family members of the arbitrator or somewhere associated with the uh, parties company, or some other disputes, or consider that I have been appointed as an expert, but my friend now is being called for appointment as arbitrator for the same parties. So that kind of category will come under green list. So the variable red list, orange list, and green list, the arbitrators coming under this category could be appointed as arbitrators. And next is seat and venue. You could, you could see the similarity of seat and venue because both has same kind of meaning in general, but in arbitration, these things has different meaning. You will be having a sentence regarding the seat and venue of arbitration proceedings in the arbitration agreement. So what does this seat determine? It determines the procedural law applicable to the arbitral proceedings. So for example, we have Arbitration Act, and if there is a dispute regarding the contractual matters, not only the Arbitration Act will be considered to adjudicate that dispute, the Evidence Act, the Contract Act, all those things will also be followed, will also be adopted by the arbitrator. So if the seat is mentioned as India or UAE in an arbitration agreement, then definitely the Contract Act, Evidence Act, that is civil law of the UAE, will be followed. Similarly, if it is India, then Indian Evidence Act, Contract Act of India will be followed. Next is venue of arbitration. Yes, this is regarding the geographical location where the tribunal has to conduct the proceedings. So now this venue sort of thing is being changed because many people opt to conduct the arbitration proceeding in online because of the expenses. So this is the difference between seat and venue. So how this seat is being determined? Generally, it is determined based on the arbitration agreement. If it is being clearly mentioned, then the seat will be the same. If it is not mentioned, the tribunal will decide. If not, uh, the parties will decide from the institution where they are referring the dispute for arbitration. Next is number of arbitrators. So there is a dispute. Now you have to invoke the arbitration proceedings and resolve the dispute. For that, you need arbitrators, and the arbitrator number, it will be generally in odd numbers, not in even numbers. So the Arbitration Act of 1996 says that if the contract specifies, sorry, arbitration clause specifies the number of arbitrators, definitely it will be the same. If not, it will be sole arbitrator. Whereas in UAE, if the arbitration clause does not specify the number of arbitrators, it will be three. The number of arbitrators will be three. In India, it will be one. So if it is three arbitrator, the claimant will be appointing one arbitrator, and the respondent, the opposite party, will be appointing another arbitrator. In UK, we have some unique provision wherein these two arbitrators, they have some conflict, some difference in deciding the procedures and all. Then they could appoint an umpire who could settle the difference between these arbitrators. And if not, there will be a third arbitrator who's called as chairman, that is the presiding arbitrator. So after determining the cases, before passing the award, the majority of the decision, that is, one party is favoring the claimant, and the other two arbitrators are favoring the respondent. In that case, the two arbitrators, that the presiding arbitrators award will be done. And next is we have specific provision for this in the Arbitration Act of 1996, which is death of arbitrator, the validity of arbitration agreement on the death of arbitrator or the person appointing him. Do you really think that with the death of the arbitrator appointed, the agreement or other dispute resolution proceedings will stop? Definitely no. So the proceedings are being continuing. So in between, unfortunately, if the arbitrator pass away, then the substitute arbitrator will be appointed, and he will resume the proceeding where the previous arbitrator stopped. And the person appointing him, for example, I have a dispute and I have invoked the arbitration, and we have appointed, the parties are mutually appointed an arbitrator. Consider that I am dead. So in that case, whether the arbitration proceeding will be stopped? Definitely no. The authorized representative of, authorized representative, instead of me, they will be representing the case, and they will be continuing. Next is immunity of arbitrator. So this is one of the key provisions, because we arbitrators have the immunity, because we do decide on crucial matters. There can be some sort of differences on the losing party, so they will challenge uh, regarding the award, whether it is not correct, or so in that case, the arbitrator is not liable for anything done or omitted if it is done in good faith. So unless until our award is made in good faith, we are very much safe under the Arbitration Act of 1996. If not, if it is done in bad faith, if it is based on fraud or biased, or if the arbitrator is being bribed, in that case, we have to face the challenge proceedings.
Sorry, Madhu, your audio is.
Next is power to appoint in construction.
Sorry, Madhu, you may switch off your video if you want. The audio is a bit wavy. Okay, please. Can you proceed?
Yes, power to appoint experts. You might have come across to this expert appointment in construction arbitration. Also, this is very much prevalent in other commercial arbitration also. So the arbitrator, he has the provision to appoint legal advisors or the technical people to assist him to decide the matter. So for his appointment and the expenses which are uh, for the payment of such experts, the arbitrator has to incur all those expenses. Whereas in India, we have specific provision wherein the parties have to pay the experts um, expenses and all fees and expenses. And it's just court's power exercising during arbitration. In the beginning, I said that arbitration proceeding is being generally followed to limit, and it is basically followed with limited court intervention. Although, if required, the tribunal could seek the help of the court for the following matters. For example, to conduct the evidences of witness and to preserve the evidences, and if they, if they want to protect some property or sale of good, or they could also seek the court help for interim relief, etc. Next is awards on different issues. The arbitrator, uh, the Arbitration Act of 1996 has a provision wherein the arbitrator has the privilege to make more than one award at different times on different aspects of the matter to be determined. So he can make either an award for the whole claim, or he can make part awards for the claims and for the counter claims. The claims will be submitted by the claimant, wherein if the respondent, the opposite party, they have their own claim, so that is called as counter claim. So the arbitrator has the privilege of making more than one award under this Arbitration Act of 1996.
Madhu, audience, they are asking to bit slow down.
All
Thank you.
right. Yeah. Next is settlement. So this settlement provision, this has been available in all the arbitration act of the country. Of course, in UAE, in India, and UK, we have the settlement provision. So consider that the arbitration proceeding has commenced in between the parties or somewhat willing to settle by communicating themselves and want to settle. So now they communicate to the arbitrator saying that we wish to settle. So in that scenario, the arbitrator has the leverage to pass an consent award, which is called as consent award. So based on the agreed terms, he will be passing an award without any reasons. And next is remedy. So since the beginning, we have been saying that there is a dispute, arbitration agreement, dispute resolution. So the dispute resolution ends with remedy, of course. The arbitrator, he could uh, assess the claims of the claimant and the respondent, and he will pass the award based on the merits of the documents submitted. So that award, that award claims could accompany with simple or the compound interest. Also, he has the provision to award interest for the expenses and cost incurred to conduct the arbitration proceedings. Next is form of arbitration award. Of course, form has been universally followed for the domestic as well as international arbitration awards. Uh, to make an arbitration award a valid one, definitely it should be in writing, signed by the arbitrator. If it is sole arbitrator, yes, he has to sign it. If it is three or five arbitrator, definitely all the arbitrators has to sign the arbitration award. And the arbitration award should have the reason for the decision, should include the arbitrator should include the reason for his decision. Unless until it is a settlement, it is a consent award, uh, the award based on merits of the case, it should accompany with reasons. If not, the party could challenge the arbitration award before the court. And it should have the place and date of the arbitration proceedings, because this date and place will be a deciding factor to challenge the arbitration award before the court. Next is power to link. This is one of the unique feature of Arbitration Act, unique UK Arbitration Act of 1996. So, if the parties are not paying the arbitrator's fee, so in that scenario, the tribunal, he has the provision to refuse and deliver the award until the payment is received. So we don't need to worry whether I mean the parties are not paying or not if you're been appointed as arbitrator. So now the award is passed. One party will be the I mean successing party and other will be losing. Either of the party, if they are unwilling with the award passed, they could challenge the award before the court only based on limited grounds. So let us see what are the limited grounds in that. First, the tribunal, the arbitral tribunal, whoever passes the award should not exceed its jurisdiction. Consider that you have a contract and you have set certain limits that only these disputes can be adjudicated under arbitration. So the arbitrator who's rendering the award should be conscious that his award should not go beyond the limit set under the contract. So if he exceeds that limit, of course, the parties could challenge such kind of arbitration award before the court. And he should address all the issues whichever been submitted by the parties. And the arbitration award should be very much certain towards the remedies. Also, it should be ambiguous. And the award, of course, should not be rendered by fraud or uh, against public policy. So the parties, either of the parties, should not bribe, or there shouldn't be any conflict of interest. In that scenario, the parties could challenge the award. Next is failure to comply with the requirements of the form of award. Consider that the award does not have the reasons. So in that case also, the parties could challenge the award. Next is enforcement of arbitration award. Uh, it is a similar, the arbitration award is similar to the judgment given by the court. So definitely the parties could enforce it similar to the judgment before the civil courts. And next is choices available to the parties. Um, this is one of the unique feature of arbitration, as we said before. In litigation, there is set principles that has to be mandatory followed by the parties as well as the as well as the counsel representing the parties. Wherein in arbitration, the parties can choose of their own on the following topics. Uh, like when the proceeding has to be conducted and where it has to be conducted and the languages they could mention in their agreement itself. If not, after the commencement also, they could mutually sit together and decide. And form of written statement, that is their the party submission, how it has to be submitted, whether online or offline. So such kind of things could also be decided by the parties. And the examination of witness, whether it has to be oral or written submissions, and the hearing, whether it is online or offline hearings, the parties could appeal to the arbitrator regarding their choices and decide. Also, the parties could request the arbitrator regarding the examination of witness, as I said before. If they don't want to strictly follow it, yes, the tribunal could determine based on the choices made by the parties.